let's move to the last panel of the discussion. Another dimension of fairness. As I said, we started thinking that we could discuss fairness in the DMA, but then fairness is going all over, so we are obliged to face it in different dimensions. And the dimension that we will discuss in this panel is fairness in the AI Act, in the Artificial Intelligence Act proposal. Let me introduce this panel with a few considerations. Okay, where we are with the act is an act that was is still in the making. The Parliament adopted the negotiating position with a strong majority in June, and the Spanish presidency aims to reach a deal by November. So we should expect to have an act, the act enacted between the end of the year and beginning of 2024. So we don't know still how will be the final text, but is an act that is in a very advanced stage. And I mean, I don't have any specific information, but it would be surprising if this doesn't go through at this point. Then if it's the final word on AI, probably it's not, and we could discuss the act under many respects, but that's not what is this panel about. This panel about is the issue of fairness, how it's treated in the Act. And the first thing I did was to check the proposal of the Commission, and the word fairness, it doesn't appear. So the AI Act doesn't speak, at least in the original proposal of the Commission, about fairness. And that's very surprising, because fairness is one of the major worries about the artificial intelligence. If there is a consolidated studies and results and investigation about problems that artificial intelligence is already causing, they are often linked really to fairness. So it's a bit surprising that the first major intervention by the European Union wasn't focused on this, at least not explicitly. However, now with the institutional interaction, fairness is in the act and has taken a much more role. And I would say that the dimensions are fairness as a principle that is part of the act, fairness in contractual terms, that is another element, fairness in procedure, and fair access also to regulatory sandboxes, that is part of the act, this attempt to innovate, controlling the attempt to innovate regulation, trying to control the evolution of the experimentation of new, more risky or more complex artificial intelligence tools. How is entered in fairness? Well, in the negotiating position text of the European Parliament, now we say in recital 9 that it is important to note that the AI system should make the best effort to respect general principle, establishing a high-level framework that promotes a coherent human-centric approach to the ethical and trustworthy AI in line with the Charters of Fundamental Rights and the values on which the Union is founded, including the protection of fundamental rights, obviously, human agency, oversight, technical robustness, safety, privacy, data governance, transparency, non-discrimination, and fairness, and social and environment well-being. In the act per se, always in the negotiating position, now the principle, the general principle is diversity, non-discrimination, and fairness means that the AI system shall be developed and used in a way that includes diverse actors, promotes equal access, gender equality, and cultural diversity, while avoiding discriminatory impacts and unfair bias that are prohibited by union and national law. So that theme that fairness is one of the worries and one of the threats that we are already seeing because of artificial intelligence tools now is getting at the center somehow, at least of the intention of the act. Then the question of how is entering the instrument is part of the discussion that we want to have here today. In the literature, clearly, fairness is, the literature is now working on issues like how to implement and when to implement fairness. And one of the main ideas seems to be that fairness should be by design, cioè throughout all the artificial intelligence cycle. The idea is we have to look at the data sets, at how the training data sets are composed to see if there is a bias, the accuracy result, the feedback loops. There is a worry that you start with a data set that is biased, then you use it, and then you bias society even more. And so you have a feedback loop, so the next data set will be even more biased. So these are the kind of systemic worries that are now in the discussion. So the answer to this kind of problem is a fair use of AI system by design that is not very easy and very simple. And anyway, the idea is not to discriminate or oppress vulnerable people, minorities, and so on. And this is one of the issues that we want to raise today. How to implement fairness? Well, it's difficult to conceive because these are very difficult processes. Clearly, there is a question of stakeholder, public participation, put the issue at the core of the design of artificial intelligence. On the other side, there is an issue of quality standards, how to check and compare these standards. And then there is at least two dimensions. One dimension that is the system design, the ex-ante fairness effort. And then there is fairness in ex post, the product use control. Because as we know, products arrive to the companies, and not always these companies have the knowledge or the resources, or sometimes the interest to really do this ex post assessment if their products and their use of the products is creating fairness or not. There are many examples from people that administration that have to decide who goes back to jail or not, people in the banks that have to decide to whom to give a mortgage or not, and things like this. They are using products that are on the shelf, that I wouldn't say that are really taken on the shelves, but anyway, from their point of view, their technical knowledge, they are almost products taken on the shelves. So they don't have the instruments. So the question is, how can we interact with this use of the products as post, and how can we prevent unfairness ex ante? This is the two dimensions that should be discussed. I don't have any answer, obviously. I'm here just to ask questions. And my question, the first question is for our panelists is really unfairness of the artificial intelligence a specific type of risks? As you know, the Act works on high risk products, implementation activities, and so on. But the question is, there are also some horizontal risks that need a specific attention. Could we enlarge the high risk category also on an horizontal view, not only on the vertical view? That's a question for me. Then we need to understand better, the literature is writing about this, the difference between fairness, equality, non-discrimination. These are interesting concepts that should be explored more. How we operationalize fairness for AI system. It is possible to achieve a fair AI system when systems operate in an unfair world. That's obviously a reasonable question. What are the tools and enforcement mechanisms that the AI Act should incorporate to attempt to have more fairness in the AI system? Which should be the notion of fairness that is used in the Act? Ethical, mathematical, legal, what kind of fairness are we really trying to pursue through this legislation intervention? What are the main obstacles to achieving fairness in AI system? And finally, what solution AI providers will can put in place to ensure fairness within their product and service, because as we were saying, users normally don't have this ability to understand and anyway to manipulate the system. So to the system producer, there is a huge responsibility from the start. These are the questions I wanted to our panel open the discussion. Our panel is a very composite and differentiated panel. We have Professor Darin Innerarity of the European University Institute that will open the discussion. That is a philosopher as origin, so it's very well a very well start for this. Then I will ask Scott Marcos, that is an economist, an engineer originally, but an economist, to give his view of the situation. Then we have Michal Gallo. We thank Michal that she couldn't arrive because of difficulties in arriving, but she's with us from Israel. And she will deal, I think, essentially with some legal aspects of the discussion. And finally, we have Audrey Scozzaro Ferrazzini from Qualcomm that I think will concentrate also on probably the last questions, how company face these difficulties. Yes. Okay, let's get started. And Daniel, you have the floor.
Okay, thank you. Thank you, Luigi, for inviting me. We are asking ourselves, in my case, from a philosophical perspective, how to make artificial intelligence fair. And I want to underline two conceptual aspects that make it particularly difficult. That we don't have, in a democratic and plural society, a shared concept of fairness, and that it is not an objective that we can rely on a technological device to solve, because it is eminently political. The first difficulty in shaping a fair algorithmic environment stems from our disparate conceptions of fairness. One manifestation of the fact that the discussion about algorithms can only be of a political nature is the fact that even if we agree on the need for algorithmic fairness, we have to decide what kind of fairness algorithms have to implement. Even where there is a broad agreement about the desirability of promoting fairness, the same idea of fairness is not necessarily shared. Our disputes about justice do not generally pit those who defend or despise it against each other, but because we have different conceptions of it, more distributive, inclusive, or procedural. Some are satisfied with identical starting conditions, while others see it as a similarity of outcomes. There are those who defend abstract equality and those who argue for an equality that would be achieved through certain positive accommodations. Its tension with other values such as freedom explains why there are so many versions of it in the space of a democratic society. A quota system reinforces equality in outcomes. A system based on anonymous curricular merit is aimed at ensuring equality of opportunities. Does equality consist in ensuring that everyone has an equal chance in obtaining a certain benefit, or in minimizing the disadvantages of the most disadvantaged? What are the most appropriate criteria of justice for a given context? What grounds would justify different treatment? Which types of justice, which types of disparity are acceptable and which are not? Another source of controversy comes from the clustering that algorithms perform when making certain decisions or predictions. Here we are faced with the dilemma that justice must strive for as much personalization as possible, but it must also perform the necessary clustering. Predictions in decision-making are inevitable and have a logic of complexity management. Let's take the example of recruitment. If we truly believed that each case is completely different, then we could do nothing more than observe how each person behaves once hired, without being able to predict anything based on the membership of a certain group. On what basis, then, would we hire him or her? There would be no more than exposed judgments. Nothing could be determined ex ante. This is clearly an absurdity that invalidates any predictive tool and its ability to make reasonable bets about possible future behavior. An algorithm or a human decision prepared according to some kind of grouping specifies and therefore restricts the elements to be considered, manage the complexity. Is all restriction a form of surrender to unfairness, or only that which allows the complexity of decisions to be reduced? The questions of groups is one of the most intricate when talking about justice in general and algorithmic justice or fairness in particular. How should categories, groups, and individuals be articulated in order to deal with discrimination that stems from belonging to a certain group, and discrimination that stems from being grouped in such a way? The mechanical application of anti-discrimination criteria to algorithms can have detrimental effects on the groups they are intended to protect. The second difficulty is the aggregation of interests and preferences. Let us suppose that we were in agreement of the conception of fairness and we only had to establish a procedure to aggregate our different interests. Would this be possible? Is it reasonable to look for a technical procedure that would determine the balanced resultant of our different preferences? This aspiration runs up against the difficulty that we are not dealing with an issue that has a technical solution. It's by technical, we mean something that spares us value judgments and deactivates the controversial nature of any public decision. Fairness is not technical debiasing, but includes a broad social analysis of how artificial intelligence is used in a given context so that biases can be better audited. Just as fairness is not a property of algorithms, but rather of the decision they contain, discrimination is not just an algorithmic issue. Everything to do with fairness and discrimination is so contextual and contested that it does not always lend itself to mathematical formalisms. Algorithmic justice cannot be an implementation that satisfies uncontroversial fairness measures. What idea of fairness and what other values should be considered in an algorithm is a political challenge, not simply a technical one. A challenge which requires accommodating various conflict interests. It is a politics that cannot be done by technicians or by algorithms without the need for citizen input. It must be done democratically, opening up these definitions to public discussion. If there were agreement about what fairness means, that is not our case, I guess, then the algorithm would be a purely technical task. It could be a matter of finding the best way to operationalize this idea of fairness. But there are some hard choices about how to measure fairness that need to be made before the technical work of detecting and mitigating unfairness begins. The problem is that the idea of fairness is a real democratic battleground, a highly contested concept in any pluralistic society. There is, I would say, there is more disagreement about the values themselves than about the means of achieving those values. No technological device can spare us the work of democratic discussion about ends, even if we can greatly facilitate the task of implementing the goals we have democratically decided to pursue. What practical conclusions could be drawn from these theoretical considerations when it comes to legislating or regulating artificial intelligence? The first is that taking into account the different conceptions of fairness, none of which is incontrovertibly better, we should regulate in a balanced way between all these dimensions and allow those who have different conceptions to govern with them. The second is that we cannot only rely on technology to solve justice-related problems because they are eminently political issues. The design of artificial intelligence has to be technically sound, but its values are not solved by technology, but at best by politics. The conclusion is that the technology must be designed in a way that allows its politicization, that it's to make sure that it is contestable, auditable, that it guarantees diversity at all times, that is subject to reflection. Fulfilling these two conditions does not necessarily ensure that artificial intelligence is fair, but if we don't fulfill them, we can be sure that it will not be fair. Thank you very much.
Thank you, Daniel.
Thank you very much, Pier Luigi, and thank you very much, Professor Innerarity, for these very thoughtful comments. So very much in line with that, where I would actually start is by asking, what do we really mean by fairness in the Artificial Intelligence Act? Fairness is a very slippery concept, and for me, trained both as an economist as an engineer, I have trouble with fairness because I can't concretely say what it is. If I look, a 2-second scan of the internet turns up impartial and just treatment of behavior without favoritism or discrimination. Well, okay, I can understand the favoritism and discrimination, but defining it as being just doesn't actually get me very far. To most of us, in any case, fairness has many faces. It's a complex concept, not easily defined, and also context dependent. Also, a key question is fairness for whom? Because fairness is often in the eye of the beholder. So the natural first place to look would be in the Artificial Intelligence Act itself. And as you heard a few moments ago from Pier Luigi, if you look at the original text from the Commission, you basically won't find it there. There are a few oblique references to the need for a fair trial, but fairness is basically not there. If you look at the submission from the Commission to Parliament and Council, it identifies several goals for the Artificial Intelligence Act, but what are they? It's that products and services should be safe. It's that they should respect fundamental rights. It's that there should be legal certainty so that there can be investment and innovation in artificial intelligence, and that there should be a single market for safe and trustworthy AI. So is fairness in there? Well, not in so many words. That doesn't mean that there's no fairness in the Artificial Intelligence Act. It just means you have to dig a little harder to find it. A lot of the Artificial Intelligence Act and a lot of its thrust, where it focuses on protection of fundamental rights, is really fairness protecting the public, protecting the individual, protecting citizens, residents, visitors from the power of the users of artificial intelligence, from the power of the vendors of products and services that use artificial intelligence, and particularly from abuse by government. So there, again, if we think of the common English language understanding of fairness, there's actually a lot of fairness in the Artificial Intelligence Act. Now, if we go to specific bits of the Artificial Intelligence Act, first think about the practices that are outright prohibited. There are prohibitions on the use of subliminal influence, on practices that would discriminate based on age or disability and would influence on that basis. There are prohibitions on social scoring, and there are prohibitions on mass use of biometrics. So clearly the social scoring and the biometrics have a lot to do with protecting individuals from abuse, especially by government. Again, fairness here in the balance of power, in negotiating power between the individual and the state. The discriminatory aspects of subliminal influence based on age or disability, again, protection against discrimination, favoritism, that's pretty clearly part of favoritism. When we go to the high-risk products, well, what are they? That includes safety of products, critical infrastructure, education, human resource, public assistance, law enforcement, migration. So once again, a lot of the provisions here are protecting individuals from the power of the state, of educational institutions, immigration authorities, and more. So fairness is implicit through an awful lot of this. And how is it done? Well, through a number of mechanisms. We have transparency to users. We have human oversight. Again, this is helping to rebalance the power of the individual against the vendors and the users of artificial intelligence. Cybersecurity and robustness, again, these protect a lot of rights, actually not just for individuals, but also for the companies that use the tools as well. Documentation, record keeping, risk management systems, and avoidance of bias is a pretty clear thrust throughout the Artificial Intelligence Act, as you've heard, in fact. So it's really there. It's just not there in so many words in the original text. Now, I'd especially call people's attention to something that wasn't in the original text because it's very important. The original text was written by the Commission before ChatGPT gained prominence. There had been tools like this, but they didn't have nearly the public visibility, the public salience that they do today. The Parliament added an Article 28B that strives to deal with foundation models and with generative AI. And I presume that a lot of that will end up in the final text for the Artificial Intelligence Act, and it's really pretty important. It really focuses on things like risk identification, testing, documentation of all of these things. And it has sections also on copyright, which presumably is seeking to balance, perhaps not in the best way, but trying to balance rights holders against those who use data, including copyrighted data, for training and that further expose it. The use for training as an input is rather different in its implications from the use of copyrighted data on the output side. But both are important, and so you see the beginnings here, perhaps, of a thought process that I would have hoped had been better addressed through the 2019 copyright amendments. Okay, anyway, you've got that, you've got focus on sustainability, you've got cybersecurity, all of that in 28B, the section added by the Parliament for foundation models, these general models, and for generative AI. So again, my takeaway is you won't find fairness in so many words in the Artificial Intelligence Act, with perhaps the noteworthy exception of the bits that Pier Luigi picked up and that I had missed. But it's there. It's there in a lot of different forms. And with that, back to you, Pier Luigi.
Thank you, Scott. I think we'll give the floor to Michal.
Hi, and thank you so much for inviting me to be part of this wonderful panel and a very important conference. I really apologize for not being able to come. I would have loved to do this in person. Let me make 6 main points. Some of them might echo the important things that my colleagues have just said, and so I will be short there. First is that I am not surprised that fairness was added to the AI Act, because fairness carries a great normative and emotional and political value, and it also enables changes when concepts change. And this was done in many other contexts. One context is, of course, the prohibition on unfair prices, which was included in Article 102 of the TFEU, and this flexibility then enabled the framers not to commit to one economic or legal view of market relationship, but rather to fill the prohibition with different contexts as the law evolved. So including fairness in the law allowed a change of view without requiring a change in the wording of the law. And the same you can see with regard to the US FTC Act, which focuses on unfair trade practices. And I would also add that fairness has what you might call legitimizing power, because who would object to fairness in human and robo-economicus relationship? And I would further argue that fairness is even more important in a supranational relationship than in a national one. So this is the first point. The second point is that at the same time, I am not surprised that fairness does not come up a lot in the AI Act, because fairness, as you so rightly noted, is an open-ended concept. It's vague, it's context-dependent, and there are many contexts with regard to AI. They are definitely not the same. Even if we take the same kind of technology, let's start, it was mentioned, generative AI was mentioned. Even with regard to generative AI, there are so many contexts that fairness notions might be a bit different in a different context. So that the bottom line here is that adding fairness does not add much certainty. And therefore, it is much better to unpack it and to be specific about what we mean exactly, at least with regard to some of the contexts in which we already have a notion of what we are aiming for. My third point is that some concepts of fairness clash, even with regard to AI. And let me give you several examples. And again, I should say, I'm not the computer scientist in the family. Both my kids are and my husband is. So I sat with them and this is what they told me, and it sounded interesting and relevant. So first of all, there's no concept of fairness in economics. If you ask an economist whether something is fair or not, he would say, well, it's not an economic concept. Tell me what you mean. There is a concept of fairness in computer science and in math, and there fair means to some, and there are many concepts, but usually it means accurate, a decision which is based on correct facts. However, if you think about it, accurate is not always fair. Think about accurate facts that lead to socially unacceptable predictions, like for example, who is likely to repay a mortgage? In some contexts, that such accurate facts might go against things that we want to protect. Fairness might also not be sufficiently wide, because if the definition in the AI Act of is that fairness equates with non-discrimination, at least in some contexts, then is this enough to protect us? Consider the question of fair to whom. Should we focus on the user? Should we focus on anyone affected? Should we focus on the developer? Should we focus on his rivals? Each of these might lead to different outcomes. And one of the most interesting issues here is the externalities that AI might impose on those not using it or not in the data sets. How do we protect them, even with regard to discrimination? Fourth point is that even if we adopt accept that the CS definition of fairness, this is not sufficient to create clarity, because in computer science, unfairness means also means discrimination, or unfairness means discrimination based on sensitive attributes. But even then, we need to unpack it further. There are two main approaches. We can think about group fairness. For example, statistical fairness for each group overall. We choose a metric and assert that it holds similarly across groups. Or it can relate to individual fairness, if we treat all cases alike, regardless of the group membership. So which one do we mean in each context? And furthermore, if you go to computer science, it uses different criteria to measure fairness that balance false positive and false negatives in the identification of attributes by the algorithm. So there are different ways of, different criteria of measuring this. For example, independence. This criteria looks at true positives and false positives out of all decisions. And fairness is asserted if the rate is similar in both groups, regardless of whether it is correct or not. For example, if going to separate cats and dogs, how many cats were, how many pictures were defined as those of cats, even if it's true or not. Another measure is separation, which focuses on errors, and it asks what is the false positive rate or false negative rate. So fairness is here, how much does the algorithm err in the same, does it err in the same way in both groups, so that the rate of errors is the same. And sufficiency, the criteria of sufficiency goes the other way around. It focuses on the correct answers. Now, for trivial cases, all three measures can be achieved at the same time. However, there's mathematical proof that computer scientists relate to, that in more complex cases, these notions of fairness in computer science may contradict. So you cannot achieve all three. You need to choose your battles. And I think that it's important to put that on the table. Fifth point is that we can learn from the problems with defining fairness, because in other contexts, because if you take, for example, section 102 of the TFEU, which prohibits directly or indirectly imposing unfair purchase or selling prices by a dominant firm, this can relate to many different concepts of fairness, because as it was so correctly said before, fairness is a very wide concept. We ask unfair in what way and to whom, and see if fairness is not a single-minded valued concept. It's a flexible one that can incorporate different meanings depending on the ideology and the goals that we seek to achieve. Just let me give you a few examples. It can apply to relate to distributed justice, or it may relate to the criterion of equal conditions among market players. It can also relate to fairness with regard to the firm who has invested in creating the resources. So that the concept of fairness by itself did not give us an answer here. Final point, the sixth point, is that, and that again echoes some of the points made earlier. In some contexts, we have unique application concerns. So let me mention two of them. One is that AI is not static. At least learning systems constantly change, and not always in a way that can be expected or predicted. And then the question is, do we want to focus on the outcomes, and that might take time because we don't always know how they're going to affect us, and then we might limit the technology? Or can we do something else? And the last point here is that even limitations that seem to be valid when applied might create results that are unexpected and unfair when AI constantly changes. And we can see that already with some limitations which were imposed on generative AI, on Chat GPT, for example, because you block one type of data or one type of answer, and the model then learns not to go there, but you might have some externalities or effects that you haven't thought about. Thank you.
Thank you, Michal. Audrey, let's see what can you do.
Thank you, Pierluigi, and hello, everybody. I'm very happy to be part of this panel. Initially, I thought that Pierluigi would like me to speak on fairness in the context of friend, but no, it gave me the surprise to talk about fairness in AI. And I scratched my head a lot on this because first, it is a complex topic. But it's even more complex for me, even if I work on the AI regulation, to speak to you on behalf of a company. But still, I have decided to move away a little bit from the fairness. I thought that Daniel, Scott, Michal would touch this and decided to talk a little bit more about AI and technology, but I will touch a little bit on the fairness. So just to tell you a little bit from my experience, and I will base it from the draft AI regulation in Europe. So when the text from the Commission was tabled, I think it was already 4 years ago, the first reaction from my team was, do we do AI? I know it sounds weird now, okay, but 4 years ago, the world was different. Do we do AI? And we were like, well, we innovate, so we should do AI, right? So we started, but it's true. We started to go and ask the engineers, and they didn't get what we were asking. So we had an engineer talking to the engineers and said, okay, look at this. Do you do AI? We had expectation that maybe we would have like less than 5 teams, doing AI. I think we stopped counting when we had more than 50. So we said, wow, okay, so let's have a look at the act. But that was a little bit, the kind of benchmark internally. Now I'm moving away from the anecdote and telling you now that, we made progress. So we have a vision at Qualcomm, and I'm going to read it to you. We envision AI processing taking place across multiple devices at the edge. I'm going to explain you what it is, but it's the opposite of the cloud. So the edge is next to you. It includes smartphone, PCs, vehicles, XR, VR devices, and basically any other devices, okay? So that's the way we sit. And our vision is based on validity, reliability, transparency, a lot of accountability, explainability, fairness, and being very human-centric. So if you want to look at the edge, the center of gravity of AI processing for us is moving toward the edge of toward the edge of the devices, So basically, the way we see it is not all the processing power will have always to go and talk to the cloud for a number of reasons. First, we're going to have more and more devices. And I think Georgios earlier today, mentioned it on another roundtable. But we're going to have more and more requests on the cloud. It is costly. It's not energy efficiency. And it's eventually not good. So we strive to create an AI technology that brings positive change to society. And as a company, we aim to act as responsible and trustworthy steward of AI, considering the broader implication of our work and taking steps to mitigate potential harms. So with policymakers, we believe it is important to gauge as much as possible and explain our approach and as well, our technology, and discuss how we can collectively mitigate potential harms. We want to be part of the conversation globally And to be fair, there are a lot of conversation globally right now, not just in Europe, but in the US, in China, in a number of forum, G7 as well, you know, is taking this approach. WEF as well is taking this approach. It's slightly different, but as well. So everybody is talking about AI now. So as Qualcomm, we welcome a common, sensible regulatory approach by government so that industry can have effective guardrails in place while we continue to innovate responsibly. We guide our approach to develop and use AI. So we develop and use AI, and I will go a little bit on the challenges, Scott, you mentioned on the copyright aspect, but we develop and use AI in an ethical way and responsible manner. And we have set up recently a generative AI council, which is a new cross-function team internally, which is developing and implementing a responsible AI principles. I'm going to list them. Fairness and inclusivity. So you were right, Luigi. Second, privacy and security. Third, transparency and accountability. Fourth, human interaction. And fifth, green AI. So Pierluigi asked me to think about what could be the challenges, and in my idea to look at only AI and technologies, I wanted to share some ideas with you for discussion. So there is maybe you all know that, but regarding, I would say, rights and AI, you have the discussion on input and outputs. And it's slightly different. So for the input, if you look at what it is, basically is to make it very simple, that's the use of large language model now. And so you have discussion, and you mentioned it was Article 28B in the draft regulation. And this has created a little bit of echo chamber about, okay, what, not just Qualcomm, but as, you know, industry, as user of technology, what do we do with it? And government as well across the world are starting to look into it. So already in a number of jurisdictions, you have a text and data mining legislation, I'm going to say that way, or regulation, with countries such as Japan and Singapore adopting like broad exception to try as well to attract, you know, new use cases. You have narrow exception like for Switzerland and the UK. You have the directive that Scott mentioned from 2019, which is called the DSM directive, with an in-between position, I would say, with an Article 3 and an Article 4, which is granting exception for research organization that they can really crunch data, I would say. And you have an Article 4, which is a kind of possibility of commercial use, but then companies having rights can opt out. And we are in the phase of, I would say, implementation in the member state. I think we are at the end. And the European Commission, I think, is launching a little bit study to see what is happening over there. And you have the US with no exception, if I understand correctly, but guidance from court for fair use. And almost everywhere, what I'm hearing is industry might need to have a bit of more guidance and clarity. But that's the easiest part. Now I'm moving to the output part, which could be related to authorship. What it is, think about it, you know, make it simple. You have a camera, you're taking a picture. Do you ask yourself, do you have the right? It seems, you know, you have. So when you use, let's say, the example of the Copilot or something similar in the future, and you create something, can you grant a right? We are asking ourselves this question right now. So, and the countries as well. So UK, Ireland, New Zealand, they are considering that authorship is given for computer-generated work for the person who arranged the work created. So it seems that for those countries, yes, there could be a protection. if you look at, for instance, for some company that would like maybe one day, to develop patent, but they will use a little bit of, help. What does it mean? There was a consultation, recently by the UK IP office, and it was decided at that time that UK believe that they have enough legal certainty. They don't need to do anything. It could grant protection. My understanding, the US, especially, I would say, is right now no granting any copyright regarding anything created with AI, and there is a consultation ongoing right now, and Canada has just launched a similar one. If we look at Europe, it seems that we have a good legal corpus. There is still a resolution from the European Parliament from 2020 saying that probably with all the tech that we have in Europe, there will still be a level of protection as long as there is a degree of human intervention. But I would say the level of the degree of intervention is still not defined. So that's a lot of challenges for Luigi, but I just wanted to highlight that. I understand as well that right now in Europe, some countries, a member state, are thinking if there should be studies about granting new right, or maybe a special, I'm not going to say copyright, but a sui generis right for not anything, but things limited when they are created with AI and human, I would say, oversight or human interaction. And those questions are asked right now within the industry. No answer yet, but there will be probably some dialogue in the future. And I just wanted to give you one example on the edge compute to explain what it is, because you might say, Audrey is talking about edge, but what it is. So take a moment, look at your phone, put it in airplane mode. Okay, and it's going to be interesting. So then what can you do? Not a lot, right? So we had a demo at Mobile World Congress with Stable Diffusion. And Stable Diffusion is creating, I would say, images. Okay, so you prompt a request. Let's say I have a picture of Giacomo. He's in Florence. It is raining. He's wearing, I don't know, a pink tie, okay, with a red dress, okay, with a hat, and look like Botticelli. Okay, so you can have this. You're still not having access to the network. In less than 12 seconds, an image is going to appear. And you're going to say, why? But that's just to explain what edge compute can do. So you can have a funny image of Giacomo, sorry. But as well, in the near future, it means that you could have control of what you want to do. You could have control of your data. You could have as well a little bit of more security because you don't interact, and you can have fun. But it's just for you to explain what can be done when you just do edge compute. It can be, of course, less fun and more work, but it's just to explain what you can do. And this is even without connectivity. So you're putting the processing next to you. Thank you.
Thank you, Audrey. Okay, we touched on different angles of this fairness in AI story. We have a few minutes for discussion. This is a discussion more open than usual, I have to say, because it's a topic that is really, as I said at the beginning, wasn't even in the directive. So, but now is entering. So let's see if there is some ideas on the importance of this. for instance, this concept that I was trying to put in the questions, is fairness really an horizontal risk on all AI more important applications, or no? Or I know that there are already risks, obviously, but is fairness really an issue? Even if I understand that we don't agree exactly what is fairness and how to operationalize it, so it's not easy.
Giuseppe Mazziotti, one question in general with regard to algorithms. We should consider the fairness of algorithms in platforms of different kinds, content related also when it comes to e-commerce as a form of AI. This is still very unclear. And we know how much they are impacting on fairness by making, markets much more extreme, making what is niche even more peripheral, creating these filter bubbles. One of my questions. And then another one, especially after having listened to the final talk, I'm working quite a lot on copyright. I see a huge problem here in terms of balance of the regulation, because we are discussing the AI regulation, which is a regulation, so sort of federal law of the EU. In copyright, we are observing tragic fragmentations, I would say, because when you mention those two provisions of the 2019 directive, first of all, it's difficult to interpret them. Second, they seem to restate a logic of proprietary control under Article 4, which is still very difficult to understand. So in the US, we are already experiencing this kind of lawsuits of artists or group of right holders that go against OpenAI, Stable Diffusion. There is already case law, which is, in the pipeline. In the European Union, I see a problem of, we do have the Court of Justice, but the Court of Justice in this field does very little. We can resort to it just through requests of preliminary rulings. I see Europe as totally unprepared also to face through the case law those kind of challenges that in the US, for very simple reasons, it's a federal state, are going to be much better defined. Not to mention the fact that courts in the US have the fair use doctrine that in Europe we don't have at all. So these couple of things, I would like to hear your opinions.
Yes, we gather a few questions and then we'll go to the panel. Please, Wolfgang.
Wolfgang Kopf, Deutsche Telekom. I was wondering, listening to that panel, whether this fairness aspect is the real issue we should look at the current stage of AI development and also the regulatory approach we are currently discussing in Europe is to somehow maybe not to the real problems. Let me introduce one of these thoughts. You just mentioned copyright. I think what we are already observing, and if you speak to publishers in science, in education, they get from these guys who set up the large language models some very interesting offers to hand in all their content for almost nothing. Yeah. At the same time, those large language model operators already sell to students and to other parts of the community for quite high prices services. That's one aspect. So that's of course touches fairness, but I think there's a much bigger issue we need to address. If you look at Microsoft, at Google, at Facebook, what is happening now is the huge acquisition mode of the entire Silicon Valley on this new models. Whatever functions they try to acquire. Now they have a problem. There's Lina Khan and there's Kanter. So what they do, they just work around it. They have contracts. I think what happens between Microsoft and ChatGPT is just a workaround of competition law, which should be addressed immediately by the European Commission and the US authorities. This is leading to another super dominant position. And then you can forget everything about fairness, sorry to say, yeah, because it's those 3 or 4 AWS mentioning who determine how this is applied and how this works.
Bruno, then we go back to the panel.
Thank you, Pier Luigi. Thank you to all the speakers. I wanted to put a question on the table for you to decide how much to tackle and whether it's broader, but I think it's important to connect it to our field. It's maybe more of a macro question. I think many have characterized AI as a general purpose technology. It's not the first time in the last 20 years that some advances in ICT and let's say internet and tech business models are called as such, but maybe this one really is. And we know in the past when there are industrial revolutions, technological and business change, for example, in agriculture, the so-called primary sector of the economy, it can have fundamental transformative impacts and shocks around it. And a lot of the debate and the public policy challenges we've had in economic policy in the last 20, 30 years, globalization, technological change, many voters, citizens, maybe they would say, well, is it fair enough? Is it fair how these changes have affected the economy and how we've been as a result? A lot of aggravation has been and concern has been created by this. So maybe it's not our job to solve it, and maybe it's not this panel's role to solve it, but are there any links between how the form of regulatory policy we're discussing here and the broader macro state intervention that can accompany these type of transformations, moderate them, mitigate them? How do they go in hand? Can we in Europe and European institutions only have the regulatory policy lever, or are there other things where this helps AI be seen by the average citizen, woman and man on the street, as a fair enough evolution in their life? Thank you.
Okay, I propose to go back to the panel and with the power of the chair, I would like to reverse the order of the intervention. So let's start with Audrey. You can pick up both other panelists or the questions of the floor.
Okay. Sorry, I'm not gonna pick the last question because I didn't really get it, but I'm happy to pick Wolfgang's question and the question on copyright and leave it to my fellow panelists. So the question on copyright and the fragmentation, I agree completely. And I have started this discussion. I'm based in Brussels with a number of policymakers and member of parliament, and I'm happy if you help me on this. I think it's important to raise it. It's slightly complicated in Brussels because we are at the end of the mandate. We are at the end as well on a very difficult previous copyright debate, and still I understand they are recovering from it, so they don't want to open something. And on the AI Act, of course, they want to close as soon as possible. You know, I think we will have 2 or 3 trilogue, but I feel like for the future, that should be probably a discussion. And as I mentioned, a number of jurisdictions looking at it, probably that's the right momentum. So I would be very happy to brainstorm with you. On Wolfgang, I would say AI and maybe gatekeeper, if I can qualify it that way. There are I'm hearing some discussion a little bit on that from some member of parliament. Some might want to include in the future, but it will need to have proper assessment. But let's say that some believe that in the review of Article 6 in the DMA, something about AI, large language model, or the fact that, you know, they scale faster, companies having them. So people start to look into it. That's my understanding. So that's the right momentum to start having this discussion. I think as well, this discussion is starting in the US. Thank you.
Michal, you have the floor.
Hi, thank you. Three very short comments, excellent questions. I wish I was there to discuss it afterwards. First, AI is a moving target, as it was mentioned in some of the questions, some of the discussions. One thing that I suggested in my work with Orla Linsky on the synthetic data is that we might use or focus more on the procedural fairness, in the sense that we should look at the expected or current results of AI system for liability, because I think that otherwise unfairness might capture a lot and create liability, and in many cases in which we would stop the technology from developing. So this is one point that we need to think about. Second, Luigi, you talked about horizontal or vertical. I would also mention another horizontal dimension, which goes beyond the act, but of course is important. That is the global digital war with regard to dominance in different spheres, which the AI Act, of course, affects. I think that if we're talking about macro, that should be taken into account. And the last point I want to make has to do with what is called transfer learning. Transfer learning occurs when you train the AI on one data set, or to do one thing in a specific context, and then the learning can be taken and applied to another context. So what happens in a world where the AI system that is used in Europe was trained in China, for example, on data that infringes privacy, but not of Europeans, of Chinese, in the sense that it doesn't infringe Chinese law, but it infringes our notions of privacy. And then the algorithm can be applied, the learning can be applied in other contexts. So there are many issues here. It's a moving puzzle.
Thank you.
Okay, thanks to all for some really good questions. On the first question, whether the AI Act needs an overall review in terms of fairness, actually, as you might gather from the comments I made earlier, my strong preference would be, rather than that the focus be on individual harms rather than on fairness as an overall concept. I think fairness as an overall concept is just too amorphous and too confusing. And I think that's actually probably the way that the debate will in fact go. Now, on copyright, I think you raise absolutely great issues, and I, of course, was, I guess, the first to mention it. To me, what should have happened, the revisions to the copyright directive were only 2019. There is a text and data mining exception that Audrey was talking about, Ms. Scozzaro, and you would have hoped that this would have picked it up, but it didn't pick it up well enough, and that seems fairly clear. And so at this point, but honestly, I don't like putting it into the Artificial Intelligence Act. I think if anything, it should be handled through modification to the Copyright Directive, which is where it belongs. Instead, the Article 28B proposes creating a huge database of all copyrighted data used, which seems to me to be rather burdensome and sort of evade the problem of the necessary corrections to the underlying law. Now, that brings me, though, exactly to the points that Mr. Kupf raised, and these issues of scale and so on. One of the problems I have with the proposed 28B, and I actually wrote this in a short analysis paper for Bruegel in July, is it applies the same burdensome obligations on all providers of foundation models, whether large or small. Now, if you take a quick look into Wikipedia, you'll see there's something like 30 models, some of which are public domain. And there's also something of a debate as to how much of a difference the investment in the model makes on quality. There's at least one article, I'm not entirely convinced by this, but that talks about I think it was a Berkeley, University of California, Berkeley effort that for hardly any cost built a model starting from a public domain source code for hardly anything, and it was getting results comparably good, they claimed, to ChatGPT. I'm not 100% convinced, but it's an interesting one. So the question really is, how much of a difference does investment make? Investment in the training data probably makes a huge difference. And here we come also to the questions that Mr. Kopf raised. Now, if a model is offering low compensation for copyrighted data, that doesn't in and of itself scare me. The question is, does the company feel obliged to provide it for a cheap price that's not or representative of the market? But I think, disregarding for a moment what I said about Koala, I suspect that there probably really is a large advantage to the well-heeled firms. And of course, those tend to be US based. As a European, I would like to make sure that our own laws, by putting very burdensome obligations on all companies, doesn't cripple our own startups. So I would really like to see a more intelligent and more differentiated approach in the eventually enacted successor to 28B. Thank you.
Okay, I think we are at the end of time. I knew that this panel would have discussed things and open more issues than could solve. But I wanted to do this also. I pushed for this panel in the program because I think that one of the idea of the new Center for Digital Society is to try to move us a little bit out of our comfort zone. And this discussion of topics like this are a bit out of our comfort zone, but I think that somehow the digital transformation is so rapid and so deep that probably there is no comfort zone. Anyway, I'm very happy with this panel and I want to thank the panelists. Thank you very much.